In this video, we're going to talk about what to do if you've been charged with a felony in Marshall County, Indiana. Felonies are serious allegations and can involve a lot of serious consequences. About me, my name's Nathan Vining. I'm a criminal defense attorney here in Indiana, and I have experience working with felony cases here in Marshall County, Indiana. I can help answer any questions for you, and we're going to walk you through the process of what to expect and what you can do if you've been charged with a felony. So one of the first, most important things is to know your court dates. If you've been charged with a felony in Marshall County, you need to know when you need to go to court, as well as what's going on in your case. Here in Indiana, we have a website, mycase.in.gov. You can go in there, search by your name, and review all of your case information to keep up to date on what's going on. There's a lot of different felony levels in Indiana. Level 1 is the most serious, down to level 6, which is the lowest. If you've been charged with a felony, it depends on what level you've been charged with as to what is potentially possible in your case. A lot of times if you're charged with a level 6, that's the lowest level, and it can be reduced to a misdemeanor. There's a lot of options going up to level 5. The advisory is 3 years of some kind of executed sentence. There is a lot more risk. Depending on where you're at, you could face potential incarceration or very likely some kind of community corrections or home detention. So even starting at the low levels, there's a lot of risk to a felony here in Indiana. The process is pretty universal across the state. It starts with the initial hearing. That's a hearing where the judge reads you through. It's the hearing where the judge advises you of your rights and then also notifies you of what the charges are against you. From there, there's a lot of discovery and pretrial motions where you can go and get what the evidence the state has against you in your case, as well as go out and find evidence that may help you challenge everything factually in your case. The court will also hold a lot of pretrial conferences. These are meetings between your attorney and the prosecutor where you go over issues with discovery, negotiate towards a final resolution of the case. And if you can't work things out in pretrial conferences, usually you'll have 2, 3, maybe 4. You'll either set it for a trial or come out with some resolution through a plea agreement and set it for a plea hearing. So it's important to work with your attorney in the case. There's 2 kind of ways you can work with your attorney. One is they were not there when you were arrested. So you want to make sure they know your story, know the situation, know why you had contact with officers. Did you consent to searches? Things like that. You want to make sure that your rights are not violated and that the proper process were followed. But then second, if you're facing a felony, you can do a lot with mitigation. You want to change your circumstances to make it harder for the prosecutor to want to convict you or the judge to want to sentence you to jail time or some hard sentence. So it can involve addressing underlying issues. So if it's a battery case, do batterers intervention or anger management. If it's a substance abuse case, do some substance abuse classes. Ultimately, if you're facing some felony sentencing someday, you want to change your circumstances to make it harder for the judge to want to give you a hard sentence. So that can involve things like getting some education, getting a job, addressing underlying issues, things like that. And I talk a lot about my clients about mitigation because I want to challenge the case on the facts and evidence and whether or not rights were violated, but also how can we improve our standing, because if we're going to face a judge for a sentencing, we want to go in there on our best footing. So potential outcomes that you can work it out through a plea agreement. You can plead a lesser included offenses, things like that. Diversion programs are also possible where you reach an agreement with the state for the charges to be dismissed under certain circumstances, or even potentially reduce things to a misdemeanor. If you have an attorney, you want to have them analyze the evidence. I'll work with you to negotiate, and then also work with you to see what you could do for as far as damage control and mitigation. So if you have questions or you're facing a case in Marshall County, feel free to give me a call or text me. I'd be happy to walk you through my opinion on your case and what we could do to help you in your situation. Here's my number. Feel free to call or text.